Welcome to Part 4 of Module 9, Resolving Issues Between the Parties. In this video segment, we will be taking a look at respondents' options and the hearing date. Respondents' options. Recall from video 3, or Part 3, we ended with serving the applicant's application and affidavit upon the respondent or upon the opposing party. And recall I said that most likely that was being done on the lawyer through letter and asking the lawyer to admit service. So now what happens when that lawyer actually has the other side's application and affidavit? What are their options? They can just take those two documents, application and affidavit, and appear on the scheduled hearing date. They don't have to do anything other than show up. Or they can object to it. And how they object is by making their own affidavit. And they put their objections or why they don't agree or if they want something different, they would put that in that affidavit. That affidavit would be sworn by that particular client. It would be filed in court and served upon the party who started that interim application or procedural application. How we file this objection affidavit, same way as application, so take a look back at the next video, making your photocopies, sending it down with the court runner, and then serving it on the other party. One final hitch: if the respondent files an affidavit objecting, the applicant can file a second affidavit. So in theory, if you have an interim application, you could have one application document, one initial affidavit by the applicant, the person who started the action, one affidavit by the respondent, and then a third or response affidavit by the applicant. So impossible to have one application document and 3 affidavits, just to keep that in mind. So before any hearing, much like a trial, any party can be questioned on the contents of an affidavit that they have sworn. So this can be done in the questioning period. Think back to Module 8 and our affidavit of records. You can do questioning for that. The affidavits that are filed in this interim or procedural application or chambers application, the other side is entitled to question the party who swore the affidavit through questioning as well. Obviously, this would be kind of hard to do if you only gave 6 days notice or 7 days notice for the application. And then if need be, any of the answers given at questioning can be entered in as evidence as a transcript during the actual hearing of the interim application. Now, special chambers, there's nothing really special about it. I don't really know how it got its name. But special chambers is anything that is going to take more than 20 minutes and you have maximum 90 minutes. It just gives the master a bit more time to deal with things that are a bit more complex. So back to our morning chambers, there's no oral evidence, so nobody testifies unless the master has a question, and the lawyers will usually answer. And so that's why the lawyers just usually attend on their own. Other than in person, the hearing can be done either electronically or documents only. Now, as we move forward in our current health climate, we might see more electronic or document-only chambers applications. Time to see how the justice system will adapt to our new reality. Let's assume we still have an in-person chambers application. What can that master do? There's really 3 outcomes. The master can issue an order. Here's the dispute, makes the decision saying this is what's happening. Or the parties, this seems kind of odd, they can go to court with what we call a consent order. They come up with a resolution before the chamber's application, but they just want the order to be made official in court. So if one of the parties doesn't go through with it, it's enforceable down the road, or the court can adjourn the matter. It's where the master says, I can't do this in 20 minutes. They'll adjourn it to something called special chambers. Or if the parties before the hearing date, so let's say the applicant said, I want to have a chambers application, the other side says, can we see if we can work something out, or I have a conflict, the parties can decide to deal with the matter at a later date, and that is adjourning at sine die. So we're not picking a specific date. So, as a legal assistant, what's your role with all of this? You might be asked to adjourn matters. Adjournments are now done online, and perhaps that can be one of the little demos I do in one of our live classes next week. I call it an adjournment form, but it's really just a web page that we fill in, and we need to do the adjournment prior to 9:30 in the morning of the hearing. So there's one last piece to really cover with these resolving matters between the parties is what does an interim order look like? As I do Module 10, we'll start out Module 10 with a little bit of a review or an introduction to how to prepare a court order. So there will be another piece that goes on with this. That's all for now.